In the context of the legal system, justice delayed can be seen as justice denied. Within our legal system, the Chief Justice is the person responsible for the administration of justice within our Supreme Courts. It is that position, while appointed by the Governor General, is done on the advice of the Prime Minister in consultation with the Leader of the Opposition. In July of 2022, Sir Ian Winder became the 14th Chief Justice of the Commonwealth of the Bahamas. At the time of his appointment, Sir Ian Winder was described as having a long-standing commitment to the rule of law. He took over the court at a time of great reform, even as the judicial system faces a lot of issues. We sit down with the Chief Justice tonight here on the record in a special edition coming from the Supreme Court. This court is in session right after this break. And welcome back to On the Record. We are coming to you from on location this week at the historic, I call it historic because not just of its age, but certainly what happens here in the historic Supreme Court building, where my esteemed guest for this evening's program is the Chief Justice of the Bahamas, Ian Winder. So welcome to the show. It's an honor to have you with us.
Thank you for having me, Jerome.
So I want to begin at the beginning, so to speak, talking a little bit about your career and what was it that really motivated you to enter this profession? And did you ever think you'd be Chief Justice?
Chief Justice, no. Well, I say ever. I mean, certainly at the start of my career, I never thought that. I entered the law a bit late. At COB, I did math and chemistry. And at some point, I determined that this law thing seems interesting. So I transitioned went to UWI and ended up doing a degree in history and law, and took it from there. Yeah.
To those of us who don't know much about the law, other than what we see on television or read, what is it that is so fascinating? Because lawyers tell me the law itself is so fascinating that it's what motivates them. But what is it? What is it like to the layperson who doesn't understand? What is the fascination of the law?
For me, I think it was more problem solving and finding solutions. And the law gives you the angles to the more you look at it, the more you can see things that may get a solution for a client or may change the way you think of something in a particular way because of the way it's written or the way it's interpreted. Yeah.
Why is this role critical, the role that you sit in now, to the administration of justice in the Bahamas?
The Chief Justice is the head of the judiciary. The judiciary being the third branch, but it's a co-equal branch of government. The others, of course, being the executive and the legislature. Legislature would pass laws. The executive would create policy and implement those laws. But the judiciary has a role to interpret those laws in line with the constitutional mandates and to resolve conflicts between individuals and between the state and individuals. So we play a critical role in ensuring the process actually works.
You've been in this position just about a year now. What has it been like for you? Have you been satisfied with some of the progress that you've made?
By and large, yes. We've had some setbacks, but I think we're moving a lot of things in the right direction. And we're getting a lot of support for some of the initiatives that we're advancing, both within and without the judiciary. Yeah.
One or two things that you can pinpoint that you think that you would say that you're most proud of?
I think the continuing the modernization and initiatives that had started. I entered the role taking over from a predecessor who was very aggressive in some of the initiatives that he put forward. Regrettably, a lot of them did not reach the stage in which he would have wished. So it was up to me to try and pursue some of those. Civil procedure reform, we managed to implement that in March, and I think by and large the process is going well. We are the last of the Caribbean region to finally reform our civil procedure rules, and we've actually done that. And we're in the stage of in the touch and go stage where we're checking errors, making sure that it's smoothly. And by and large, the bar and the profession is very supportive, and that's good. Yeah.
Tonight's show really is, we've deemed it reform and regulation. And it's in line, we think, with something that you have said, the need to get creative in creating reforms. How does proper reform help with the crime situation? And I'm starting with that because that is the most sticking issue. That is the issue that really, and the issue of crime is really the thing I think that grieves so many Bahamians. It's the thing we talk about the most, and I think that concerns us the most.
Yeah, and it certainly concerns us in judiciary. We only get the beaten with the stick when, of course, someone, and the clear example, obviously, is where persons on bail commit other offenses or alleged to commit other offenses. But reform is necessary because we need to, beginning with the pace at which criminal matters take place. Some matters are very old, the backlog is extensive, so we need to be creative in the way we address and attack those issues. We can't try ourselves out of all of these cases. We need to find ways to get into plea bargaining, perhaps some sentencing reform. We need to reform the pace at which a criminal trial takes place in the Supreme Court, and we all accept that it's far too long. Numerous factors account for that, but there are things we could do. For example, if through legislative intervention, we could shorten the process by taking all of these evidential disputes out of the trial process, engage them before the trial actually begins. Whether some of them are successful or not would determine whether, in fact, the state intends to proceed with the case. One less case on the docket, one less issue to deal with. Bench trials. We need to consider the opportunity for judge-alone trials. The jury system, as it is, lengthens the process. That can't be disputed. You have a fundamental right to a jury trial. I accept that the Constitution puts that in there, but it's open to an accused to elect, if he wants his matter resolved quicker, to elect, if we had the process in place, to elect a judge-alone trial. They do it all the time in the magistrate's court by selecting to be tried in the magistrate's court as opposed to by jury in the Supreme Court. So if we provide the appropriate incentives and the basis for a convict or an accused to elect, then I think that would shorten the process as well.
What are the impediments to these things? Because they are, on the surface, it seems as if a lot of these things that you've spoken about would help to move the process along, because I know the delay in the courts is really an egregious issue for a lot of people. What are the impediments to these things, or are they in play as we speak?
Yeah. I think some of them are in play. I haven't seen any of the drafts or any of it, but I know that those are initiatives that are being looked at. Whether they actually come to fruition is a different issue altogether. I'm not sure what, in terms of impediments, I don't know that there are impediments other than the natural ones, what the law currently provides, what the constitutional mandates are. This issue of bail, for example, is not as if judges are immune to what the cry is in the public, but the Constitution provides certain imperatives which judges are required to follow. You have a right to the presumption of innocence. That has to be balanced with the needs of the state and the country to keep crime at an irreducible minimum.
We'll talk a little bit more about some of those issues a little later on now, but I want to talk a bit about the police and how can the police work along with the judiciary to ensure a smoother process. Because when you talk to the police, they'll say, well, Mr. Sawyer, well, we do our job, we catch the criminals. We've done our jobs, but what is it that can be done better to ensure a smoother process and even a shorter time from the point of arrest and charge to conviction and disposing of the case?
In some instances where persons get bail, for example, the judge has to do an assessment of the state of the evidence that's placed before them. So it's not just a question of placing the person before the court and it's the end of the matter. The police have to ensure that the evidence is tight. I think there's too much of a reliance on confessions. We need to engage more in technology, DNA, forensics. We need to engage that process more to ensure that when judges are faced with assessing the evidence to determine whether someone is going to spend the next 2 or 3 years of their life in jail waiting for a case to come to trial, to determine whether, in fact, the strength of the case is there.
Do you think sometimes because of the heinous nature and the frequency, there's this tendency to almost rush to judgment? How could you give this person bail? How could they not be locked away? Do you think that's lost sometimes on us, that there is this presumption of innocence, despite how heinous it is?
Yeah. We all accept that the situation on the street is dire. I mean, we all read the papers, we all watch the news, we all see loved ones losing their lives. So there definitely is a tendency to side with the incident rather than the individual who is alleged to have done the offense. But the law provides us to cloak him in innocence until such time as he's been found to have committed the offense. Yeah.
One of the things you mentioned previously is the issue of the backlog. And from the time that I was a young reporter, when we had quarterly sessions of the court, we always talked about the backlog. And that continues to be an issue. How is it that we've gotten to such a huge backlog that is so difficult for us to address?
Probably a combination of factors. Besides the growth of the society, we've become a very litigious society. So the civil backlogs continue to grow because persons like to have their day in court. We need to encourage persons to resolve their matters outside of the court system, or to use the court system in a way that it resolves the dispute rather than having the matter strung out until it gets to a trial date. The backlog, every country has a backlog. Our backlog, and part of what we're trying to do is to be able to measure the backlog and be able to determine exactly the extent of it, to be able to manage it, to manage it better. And that's an ongoing process where when I first came to the bar, we had I think maybe 4 or 5 judges in the Supreme Court. It took a while for us to realize that we need to increase manpower, increase the amount of courtrooms, increase the availability to have these matters resolved in a timely fashion. And some of that is catching up with us, but we're at a pace to try and get a handle on it at least.
Is there a shortage, or are there adequate criminal lawyers to be able to deal with the amount of cases?
The clear answer is no. There is definitely a shortage. There's not enough.
Why? Why do you think that is?
Criminal law isn't one of the sexy areas generally that you're gonna have to get your hands dirty, as it were, in terms of the interaction with persons who may have been alleged to have committed these offenses. And I think that of itself makes it less attractive. Certainly, some, on the other hand, of course, some lawyers who do criminal work get their names in the papers and get publicity. But it's not an area that seems to attract lawyers from law school. And I think the bar and the law schools perhaps need to change the focus to encourage lawyers to pursue criminal law because it is a necessary adjunct to the profession
I want to spend
on both sides.
Yeah, agreed. Good advice. I want to spend a little time speaking about how we can address the problem of speedier trials, or not so much a problem, but how do we get to speedier trials? I think you began to touch on it a bit, but what is the remedy, as you see it, in disposing of cases a lot faster? You talked about some things, but I want to delve into that a little bit more.
Certainly, we need to reduce the actual trial process where the jury is involved. And certainly, we need to make better use of technology. Some of it is happening, but we need to make better use of technology in terms of delivery of evidence. But I think the main assistance will come if we're able to take all those evidentiary challenges out of the trial process, and the trial process just smooth.
For the layman, what are the evidentiary challenges? If you could explain that to people who don't understand.
For example, an accused is alleged to have confessed to the police. That process, as it currently stands, takes place after the trial begins. Say, for example, there may be some forensic evidence that there may be a challenge. The accused may be suggesting that the chain of custody has been broken to the extent that the evidence can't be reliable. Mm-hmm. Any number of challenge to the evidence that the state intends to adduce in evidence is an evidentiary challenge. So if we can get those challenges done early, let's say unfortunately your trial date is a year away. Mm-hmm. Those evidentiary challenges can be taking place during the course of that period. So when the trial begins, what's will be in evidence, which will not be in evidence.
So there's no question about what is admissible, and you don't have to deal with it in court.
In court, and you go straight through. The witnesses come, give the evidence. At the end of the day, case summed up, jury gives. There's no break where the jury is asked to come back next week Tuesday, mm-hmm. because there's an issue that the lawyers want to deal with the court. When that happens, those are evidentiary challenges that are being brought through. Let's say, for example, there was a confession, and we did the evidentiary challenge for the confession. It took place outside of the trial. If that was the only evidence connecting the accused to the offense, and it's determined that the confession was improperly taken, case is done.
No case.
Yeah, the case is done. The prosecution, knowing that that's the only evidence they have, they will end the matter.
There is discussion as well about plea bargaining, and how do you think that would affect the backlog and even the time it takes to dispose of these matters?
That is a necessary element to speed up this process. The state cannot try all these cases. In every other jurisdiction, we're the total opposite. In the U.S., they brag about 90% of their cases are pleaded out. Mm-hmm. In our case, 10% of our cases are pleaded out. So we have to try 90% of these cases where they only have to try 10%. And that is a balance.
They have more people and more resources, etc. Yeah.
So you see that are challenges. Mm-hmm. But everybody seems to I don't know whether it's the incentive isn't great enough to reduce to encourage them to settle or to take a plea. For whatever reason, there seems to be a reluctance, and that we need to find the right balance to be able to get that moving. And perhaps sentencing guidelines may assist if the sentences are clear and the discounts are clear. Then that perhaps can assist the process.
I want to deal with the bail issue, but I want to wait on that. I want to ask you though, there's a saying that there is a feeling, I should say, that the case backlog, the time that it takes to dispose of matters, particularly criminal matters and the more serious matters, may be leading to a continued escalation in crime, because people feel as if cases aren't being disposed of. I'm allowed to languish out on bail for X amount of time. These matters are not being heard. I commit a crime and it seemingly goes unpunished. Do you think that is in any way contributing to this notion in the society that I can commit a crime and I'll get away with it or nothing will happen or I'm just going to continue to do as I like?
I don't know that it can be ruled out. Those are a lot of those are factors we'll probably never know, but I don't think it can be ruled out. And certainly, it's incumbent on us to ensure that the system moves at a pace that those sentiments aren't allowed to fester and become real.
Mm-hmm. Is that a concern, though? Do you think from members of the judiciary? Is it something that you all grapple with sometimes?
It has to be a concern. We live in the society. And we see and hear, but regrettably we have the balance that we have that we have to keep between the right of innocence and the safety of the state. It's a balance that besides constitutional mandates, the courts above the Supreme Court have set standards that we have to achieve.
So this is a good point for us to take our first break in the show. We have lots more to talk about and lots more to get to, so stay with us. The special edition of On the Record with the country's Chief Justice continues right after this. You're watching On the Record, and tonight's episode is coming to you from inside the Supreme Court building, seen by many as a seat of justice in so many ways in our country. I'm happy to have as my guest the country's Chief Justice, Sir Ian Wine. Dear sir, as we went to the break, I indicated that I wanted to have a discussion about bail. And it really is a topic that continues to rear its head, whether it's among ordinary people in the House of Assembly, with the police, but I guess a fundamental question is, why do we have so many individuals who are charged with murder out on bail? How has that been allowed to happen?
The fact that you're charged with the offense of murder does not prohibit the grant of bail. There seems to be a view that once you're charged with murder, you're not allowed bail. That is not the law. That is not the law. Very recently, the Privy Council on a case from Trinidad made it explicitly clear that the fact that you're charged with murder does not prohibit the court from granting bail to you. Certainly, it is a factor to be taken into account because the seriousness of the offense for which you're charged is clearly a factor to be taken into account, but it's not the only factor. There are other factors like as I indicated, the presumption of innocence, the strength of the evidence in respect of the case that's been before you, whether you will abscond if granted bail, or whether you will interfere with witnesses or the case. So there are many other factors, and when the state asks that bail be denied to you, they have to demonstrate that all of those factors could only lead to the conclusion that bail should be denied, not just the seriousness of the offense, regrettably.
And when you have people who are on multiple bail, they're out on bail for multiple crimes, sometimes 2, 3. Explain to us how that is allowed to happen when it, again, from the untrained eye, it would seem this person continues to commit crimes. So how is it that individual is out on 2 and 3?
They continue to be accused of committing crimes.
Yes, pardon me, yes. They continue to be accused.
Okay. So we don't know all the factors. So let's say you were granted bail, you had committed that you're charged with the offense of murder, you were granted bail. You could have been in custody for 2-3 years prior. The fact that you have multiple offenses doesn't mean that in that period you could not have been in custody for a considerable period of time. If your trial, if you're not going to be tried within a reasonable time, you have a right to be released. And the fact that you are charged with committing another murder whilst you're on bail, doesn't just add up to say that you were on bail for multiple. You have to look at all of the factors and not just the nature of the charge that you're accused.
Is the fix to all of this disposing of these cases within a reasonable time?
Absolutely, absolutely. That I think it begins and ends with that, and that is an issue that does not rest solely with the court system. They have to be prosecuted. We don't prosecute cases. We only hear the matters that come before us. The police, the prosecution, the defense, the court. We all have to work together to fix the challenges that we have. One arm can't do it by itself.
Is it a challenge when you have a small amount of criminal lawyers now trying to manage several cases at the same time?
That is really part of the problem. To some extent, we're slave to their diaries. You're charged with murder. Someone has to represent you. Part of it, I think, is trying our best to increase the capacity in the public defender's office, which I think, when it was brought on, I think it was certainly a game changer. But they quickly filled the capacity because there are limited amount of lawyers who are engaged there. I think we need to triple their capacity overnight to be able to reduce the time frame in which someone can adequately represent an accused, because there are so few criminal lawyers at the criminal bar.
And it's true, because we hear, from the news perspective, we hear the same lawyers representing the same criminals, or the same accused, I should say, time and time again. I do want to move forward a bit, though. In May, it was announced that the judiciary would reintroduce the dedicated gun court. Why was this necessary?
The Minister of National Security and the Commissioner met with us, and we had, just a step back, we had a somewhat dedicated gun court in the past. We just, what began to happen is other magistrates started to be assigned gun cases because of the massive amount of numbers of cases that have come in. So we were approached by the commissioner and the minister to add to capacity by introducing a dedicated gun court in addition to the.
I think this is the third time, maybe the third time, that it has been set up or looked at specifically.
Maybe it's the second or third.
Okay.
But certainly, I think when the current chief magistrate, who is now acting on the Supreme Court, this is Joanne Ferguson Pratt. She had been identified as the gun court magistrate, and I think that had carried through. But certainly, the new incantation, it's a dedicated gun court, but we still have other magistrates doing gun cases because that one court will not manage the capacity. But certainly, the intent is that simple possession matters that are likely to be finished very quickly will head to that court and get the matter resolved quickly rather than be lost in the fray with all the other cases.
So the idea is to be able to expedite maybe the smaller cases a lot faster.
That is the plan.
Okay. All right. Should there be, or do you think there should be, mandatory minimum sentencing for unlawful gun possession? Would that?
We've been seesawing back and forth with that cross administrations. I'm not opposed to it in the sense that it sets the tone as to what the state considers the starting point should be. but the challenge has always been there should be some discretion, and not every case is amenable to a fixed sentence. There may be extenuating circumstances where that fixed minimum will really cause an injustice to the person who would have committed the offense.
Do you think this, though, if you had a minimum sentencing guideline, do you think that would be a deterrent?
Deterrents are always speculative because at the end of the day, you never actually know. But I think that it likely could be a deterrent. But there's always the constitutional issue in the background in terms of taking away the discretion from a judge to make determinations. And I think it would cause the issue with the mandatory death penalty cases, where there should be some judicial determination as to what's the appropriate sentence. So
you think a mandatory minimum would work, but there has to be the ability to have some discretion on the part of the judge.
There should be some discretionary element in it.
All right, I want to talk a little bit about a recent ruling that has gotten a lot of media attention, allowing children that are born to a foreign woman and Bahamian men to be Bahamian citizens at birth. How does a ruling like this help the movement toward inclusivity?
Yeah. I think it makes a giant leap forward. Prior to on the prior interpretation, those persons who we now know are Bahamian citizens would have to wait 18 years to apply to become a citizen of the Bahamas, when their father is a Bahamian citizen, and they not have the benefit of their father's nationality. So those children grow up on the outside of their own society, and that can only be a recipe for challenges. On the flip side, those persons grown up with the full rights of citizenship, their outlook on life, the opportunities that they would have would be totally different, and they'd be a totally different citizen.
In May, a former Attorney General said that the decision to allow children born out of wedlock to foreign women and Bahamian men to be citizens highlights the ongoing discrimination against women. Does this appear to be discrimination against women from where you sit?
The interpreting the law as it is?
Yeah.
Let's start off with the premise that the Constitution is biased against women. That is an undeniable fact. The child of a Bahamian woman, regardless of where the child is born, was always an unmarried Bahamian woman. Regardless of where the child was born, is always a Bahamian citizen. The child of a Bahamian man, regardless of where he was born, depended on whether he was married to the woman or not. I'm not sure it's fair to say that demonstrates discrimination against women, but rather equalizing the state between unmarried men and women on a whole. It was one of the areas where men were discriminated against. And men are still discriminated against in respect of their children born outside the Bahamas if they're not married to the woman. Mm-hmm. So, but I accept that the Constitution is more skewed against women than men. That is undeniable.
Just from a societal perspective, do these things really help to create some of the issues that we face as a society, where we have people who are born here who are not able to gain citizenship, and the issues that come along with that? are these the kinds of things that help to erode at our society and create some of the issues that we have?
Yeah, I think it does. It creates a equality is justice. So when persons are treated unequally, even if the Constitution provides that it could happen, it doesn't lead to, it will not lead to a sense of belonging and fairness to your own society. And I think that could only lead to some of the challenges that we have.
How do we, from where you said, how do we address this whole issue of citizenship? We've gone to a referendum on more than one occasion, and that route has not worked. Is it just a matter of changing the law outright? How do we address this issue, particularly when it is still such a divisive issue for us in so many ways?
Yeah. I gave a lecture at the Eugene Depute Law School, I think in March, and I expressed my personal view, and this again is my personal view. I think the law just needs to be passed, even if it's only by Parliament, to level the playing field for everybody. I don't know how anyone could be opposed to such an eventuality, but I think Parliament is empowered. But I know Parliament is empowered to make laws for peace, order, and good government, and certainly the provisions on citizenship permit Parliament to pass laws to equalize the playing field for men and women.
Before we go into the break, I do want to switch gears again. I want to talk about some of the work that you've been able to do within the system, and one was the digitization of the court and being able to have those court records digitized. How have you seen that since that happened? How have you seen that impact the work of the court and also the administration of justice?
Well, that's still a work in progress.
Right.
So the contract for digitization only ended in February of this year. So the records have been digitized, but that's only the first step. They have to be placed into a case management system, and that is an ongoing process. We expect by the last quarter of this year that will be a completed process, and that it is hoped will end all of these issues with paper files being lost, documents being missing, and we think that will speed up the pace at which matters can be heard, and certainly speed up the issues in respect of trying to keep a case together. So the ICMS is expected to come on board, and with that will be the electronic filing. So persons will be able to file their documents without having to come into the court system. The document goes directly into the court file, accessible to all the parties, and certainly will speed up the way in which we're able to manage the system.
And again, does that help in alleviating some of the issues that we're facing with backlog, and not just in criminal matters?
Certainly. Well, certainly it will have, I think, a much greater impact on the non-criminal matters, which are all a lot more paper heavy, as it were. Decisions will be able to be rendered much quicker by judges once the matter is resolved, because the issue of transporting these documents back and forth, judges can be able to work from home more freely, having access to the complete file, be able to access the images, to be able to put them into your judgment. So it will greatly impact the pace at which matters start and finish.
All right, so we are going to take our next break in the show, which is really our final break. When we come back, we're going to talk a little bit more about the future of the judiciary, the new court complex, how some of the things that you want to accomplish. What's the timeline on some of those? And so we've got a lot more to talk about, so stay with us. We are in the midst of a conversation in an historic building. It's the first time we've ever brought On the Record into this building, so stay with us. We're going to be back with more right after this. And we are back here on the record, coming to you from on location at the Supreme Court building in Bank Lane. Honored to have as our guest tonight the Chief Justice of the Commonwealth of the Bahamas, Ian Winder. We're discussing reform and regulation in the Bahamas. Sir, I talk about this being an historic building, but in many instances it's an old building, as many of the buildings that house our courts. Why is a new Supreme Court judicial complex needed?
You begin by again, historic and old. So these buildings they've been around and they've been part of the court system for as long as anyone can remember. At one point, the entire Supreme Court was in this building, and only two courts were being used: the Chief Justice and another judge. 50 years later, and that state was pre-independence. 50 years later, we have expanded our base. We're in Ansbach, and then we have 5 courts in this with the Swift Justice Building, as it got its name, but it's annexed to. Those courts in those buildings, and I'd invite you to have a walk over there when you finish. Those buildings are barely habitable.
Wow.
The judges in those buildings they're not fit for courtrooms, but we have no choice because the need and demand require that we have and we operate courts out of that building. Our country has grown to the extent where we need modern facilities to be able to process these cases at a efficient and proper rate. That can't be done adequately in the current plant that we operate. We operate from Ansbach, the old Ansbach building. We operate from Swift Justice and Annex 2. We operate from this building. We operate from the Hansard building on the corner. We operate from George Street, where the civil registry is. We operate from a building where the court reporters are down on the main Bay Street. So our plant, our campus is all across the place.
I didn't even realize you were in all those buildings.
Different disparate locations. Very inefficient. Having a complete court complex allows us to benefit from all the efficiencies of being able to have all of our personnel, all of our plant in one location, to be able to benefit from all the synergies that would allow.
Do these conditions help to prolong those backlogs that we've spoken about as well?
It has to. Whether it's simply court having to be delayed or canceled because of leaking issues, because of air condition issues, because of the poor plant. This building, for example, that we're in, beautiful building. At the opening of the legal year, we couldn't use this building as we normally would have, because this building was totally destroyed by water. Over the holidays, the water came through the top of the building, straight to the bottom, destroying practically all of the equipment and the courts themselves. These buildings had to be completely renovated to be able to function again. I commend the government for committing the resources to bring this building back to the state in which it is, and the contractors did an excellent job. But that just demonstrates the kinds of challenges we continually have with leaking roofs, because the buildings are just old. And over the years, they've not been adequately maintained to permit them to have had the life that they probably.
Is the project still on the board for the new judicial complex? Is that still happening?
I'm encouraged that it is. I saw the Attorney General gave his presentation in the Senate during the budget communications. and they've committed to bringing the complex to life. They've acquired the building at 50 Shirley Street, which is at the base of that block that we hope to build the complex. The intent is to push down Rodney Bain building and have a building come up on that site to house the complete court complex. I'm encouraged that the government will come through with their commitment to do it.
What is the need, or do we need, or how many specialty courts do we need? Do we have the adequate amount? Do we need more? And what would be the benefit of more specialty courts?
Well, specialty courts provide purpose-built spaces to permit certain types of matter to be heard more efficiently. And perhaps the best example of a specialized court is a family court. There is on the way the plans to build out a family court on a site that the government has acquired on Burnett Road. And that site will have intended to have 3 judges doing family, dedicated completely to family court matters, 3 magistrates dedicated completely to family court matters in that space, where social services, the police, mediation facilities, daycare, to permit, and all of the services attending to family-related matters to be housed in that facility. The courtrooms will be built different from the ordinary courtrooms because the matters are generally intended to be more conciliatory in their resolution, to tone down the ornate court environment that you would have, to allow for a resolution of this between family members to be proper.
And to be quite honest, this can really be an intimidating setup for a family court matter.
Yeah. But the other specialty courts intended as also a commercial court, and the hope is that in the environs of the government, I understand, will acquire a space next to where the new court complex will come, to allow an arbitration center and a commercial court to be developed.
Why is a separate court needed for sexual offenses?
I was about to say also, sexual offenses, there will be a sexual offenses court. The hope is when we vacate this building for the Supreme Court complex, this will become the new sexual offenses court. So we'll have 3 courts dedicated primarily to sexual offenses matters. The other areas will be dedicated to allow for the victim to be housed and enter into the building in a protected way. So when she comes to court and faces she or he comes to court and faces the accuser, there will be no intimidation, or there will be no fear in coming to give the evidence. So a dedicated sexual offense court will allow separate entrances for the parties, the victim to be, or the victim to be separated, to allow her privacy in the and just come to court and give her evidence and not be intimidated.
It is worrying to me as a Bahamian when we're looking at 3 sexual offenses courts. That seems like a lot.
Regrettably, and the data demonstrates that the single most types of crime in the Bahamas is probably sexual offenses. Regrettably, one sexual offense court could not deal with the amount of cases that we have, and it's regrettable. That's what the data demonstrates. And so if we just had one sexual offenses court, and every sexual offense was pushed to that court, you will end up with a backlog of sexual offenses if no other court is sitting to hear them.
How many do we have now dealing, or is there a specialty for that, or are they handled through
At present, we don't have a dedicated sexual offences court. So each judge in the criminal division would have several cases on their docket. There'll be sexual offences.
Aside from dealing with the backlog, though, or dealing with the high volume, I should say, of sexual offences, having a specific court to deal with them, what else would that do? I mean, would there be a special training, or how would they be handled a little differently, aside from, I think you mentioned the entrances, but what would that do to help to adjudicate those matters?
Yeah. Well, one of the main benefits of the sexual offences court, and having 3 of them, and having enough of them, is to ensure that the matters are dealt with quickly. Because the challenge you have is that as sexual offences age, the person who has been violated age, or as they move on, they tend to want to put it behind them, and the offender goes free. So the intent is that the cases were moved much more quickly, and so the sexual offences properly operated sexual offences court will have, like the family court has the attendant service, the social services, some of those same victim care type services will be available, and to clothe the victim so that the victim feels comfortable in going through what is clearly an ordeal.
All right. Sir, recently magistrates have criticized the selection of a junior lawyer with no magisterial experience acting as a chief magistrate. Your thoughts or response on the matter?
The gentleman selected, any objective observer familiar with his work would never regard him as a junior lawyer at the criminal bar. He's 13 years in, as I understand it, at the bar. The magistrate, the qualification for magistrate is 5 years. But the gentleman selected is a very respected criminal advocate. Most of the work I understood he did was at the appellate court level, and I have not had heard any adverse comments personally as to his selection or his ability to do the job. And one of the things, it's an acting position, but one of the things is helpful is to have an outside look coming in, having been on the outside, seeing the challenges, and having your ideas as to what can be fixed.
We call them a fresh pair of eyes.
Fresh pair of eyes. And I think it would all go well for the system.
All right, finally, I know your predecessor had put a lot of work and was very keen on the court services bill. What is happening with that? Has it been addressed? Is it moving forward?
I'm advised that the intent is the court services bill was originally introduced in the prior administration. It had not been passed before they demitted office. The current administration reintroduced the bill and expressed their intent to pass the bill. I'm hopeful that the bill will be passed, because as my predecessor described it, it is certainly a transformative piece of legislation that will give the court the financial, operational autonomy that will give life to the independence of judiciary in all its forms.
So we are out of time, but I want to just give you an opportunity just to speak to, what do you expect or hope for the rest of your tenure to be like? You're now pretty much 1 year into the role as Chief Justice.
What I've learned in the last year is that you never know what to expect generally from day to day. But certainly a lot of the planning that has been gone into the I think hopefully will yield fruit. Planning in terms of the family court complex, the main judicial complex, reform in the civil procedure. There's a plan to introduce a mediation center. The intent is, as I indicated, in the same way you can't try ourselves out of these criminal trials, we can't try all these civil cases. So my hope is to establish a mediation center. We will introduce court-annexed mediation to ensure that matters that progress to the civil justice system require some effort at trying to mediate the dispute. We'll engage the local mediation community, which is very, very large and very engaged, and we'll use them as mediators with the use of the mediation center to mediate some of these civil cases and try and put an end to this backlog.
So thank you very much. We are out of time. Thank you for agreeing to sit down to have this one-on-one with us. We learned a lot, and we certainly wish you the best in going forward. And I know you have your work cut out for you, and so we wish you all the best. And certainly from where we sit, we'll be keeping an eye on the progress and helping to keep our viewers and our audience informed about the changes that are taking place. Well, all the best to you, sir.
Thank you. Thank you for having me, Jerome.
All right, and that's going to do it for this edition of On the Record. We'd like to thank our guest, the Chief Justice, for sitting down with us today on location in this historic building. We hope you've enjoyed our show, and we look forward to seeing you next time right here on The Record. Until then, I'm Jerome Sawyer. Enjoy the rest of your evening.